Hello, my name is Lori Schaefer, and in this video we will be discussing due process. Due process hearings are available for families of children who are thought to be disabled or have in fact been identified as having a disability. Due process is also available for students who are thought to be gifted or have in fact been identified with having giftedness. An important fact to know is that due process hearings are very similar to actual trials, with the hearing officer acting as the judge. The LEA is required to be represented by an attorney. The parents may also use an attorney, or they may represent themselves. If a parent does not have an attorney, they are called a pro se parent. Most of the due process requests that come into the ODR office are initiated by parents and guardians. However, the LEA can also request due process. Due process can be requested for issues regarding identification, evaluation, placement, or a free appropriate public education, which you will hear referred to as FAPE. Who are the ODR hearing officers? The Individuals with Disabilities Education Act, which we refer to as IDEA, requires all hearing officers to have extensive knowledge in special education law and possess the knowledge to legally conduct a hearing and write a decision. Although the law does not require hearing officers to be attorneys, because of these strict requirements, most hearing officers throughout the country are in fact attorneys. Pennsylvania is no different. ODR employs 6 full-time hearing officers. 1 part-time hearing officer is responsible for gifted education cases. The hearing officer biographical information is listed on the ODR website. IDEA requires that when a parent requests due process, the LEA must hold a resolution meeting with the parent within 15 days of the due process request. This allows the parties an opportunity to reach an agreement before going to a due process hearing. The parent and the LEA may choose to waive this meeting in writing, or they may agree to use mediation instead of the resolution meeting. ODR gathers data on the outcome of the resolution meeting and reports the information to the Bureau of Special Education, or OCDEL, for early intervention cases for use in federally mandated data reports. While mediation is less formal and more low-key, due process is more like a formal court proceeding. Each side presents their witnesses and exhibits. They are given the opportunity to question the opposing side's witnesses and question the other's exhibits. All of this is done on record, under oath, with a stenographer writing everything down. A transcript of each session is prepared and provided to the parent or the parent attorney at no charge. At the end of a due process hearing, the hearing officer will write a decision. The decision is based on the evidence, findings of fact, credibility of witnesses, and conclusions of law, determined through the hearing session or sessions. Oftentimes, however, once a hearing starts, the parties resolve the case on their own. This is called settlement, and it happens very frequently. If either party disagrees with the hearing officer's decision, an appeal can be filed in state or federal court. The hearing officer will provide appeal instructions along with his or her decision. Now that we have reviewed due process and mediation, the 2 services all states are required by federal law to provide to parents and schools, we will now turn to the many services ODR offers, which are not mandated by law, but provide options for parents and schools to resolve disagreements in other ways. These include Special Education Consult Line, IEP IFSP Facilitation, Resolution Meeting Facilitation, Hearing Officer Settlement Conference, and the Creating Agreement Training.